You woke up at your usual time and started your day. You walked to your desk and placed your coffee on it. Right at that moment, someone calls you into your manager's office. You sit down across from your manager, and they tell you that today is your last day. You will no longer be working with us. What would you think in that moment? No reason, no warning, nothing. And inside, you asked yourself, can they do this? Most people think, I need to receive a warning before being fired. They have to tell me the reason. I have rights. These thoughts feel completely normal, and that is exactly why they are so dangerous. Now, imagine this scene. David has been working at the same company for 5 years. He has never been late. He has never received a complaint. His performance reviews have always come out positive. Then, one Friday afternoon, a moment he never expected arrives. Human resources took him into a small room. Your role at the company has ended as of today, they said. Nothing else. After signing a severance package, hand over your card and leave. After getting over the initial shock, David asks, is this legal? Don't I have a right to a warning? Why didn't they even tell me why they let me go? The answers to these questions will surprise you too, because if you are working in America, you absolutely need to know this. Your employer, in most situations, can let you go without showing any reason and without giving any warning. And this is completely legal. There is even a name for it: at-will employment. What does this mean? Think of it this way. As an employee, you can resign whenever you want without giving any reason. Your wishes produce a result. Your employer has the same right. The employer can also end the employment relationship whenever they want, for whatever reason they want, or they can end it with no reason at all. Sounds pretty harsh, doesn't it? But this is one of the fundamental topics of American employment law, and most people either know it wrong or don't know it at all. So does this make everything legal? No. And this is where the story gets interesting. This story is going to get more interesting, and you are going to learn a lot more. By the way, if you subscribe to my channel, you will become more informed through videos like this. Let's continue from where we left off.
The principle of at-will employment has a history of about 150 years. Its foundations were laid in 1877 in a Tennessee court. The idea at the time was, if the worker is free, the employer should also be free. Both work by choice, not by contract. Today, this rule applies in 49 of America's 50 states. The only exception, Montana. In Montana, after certain conditions are met, you are required to provide a valid reason to terminate employment. But pay attention, this rule is not unlimited and open-ended, and this is exactly the part that many people miss. There are situations where your employer cannot fire you. First, discrimination. No employer can fire you because of your race, gender, religion, age, disability, or national origin. If they do so, they have carried out an illegal termination. At the federal level, Title VII and other laws provide protection against this. Second, retaliation. Did you report the company to authorities or the police for safety violation? Did you report sexual harassment that took place at the workplace? Did you seek your right to overtime pay? If you are fired after these actions, it may be considered retaliation and you are protected by law.
Third, contract. If you have a written or verbal employment contract with your employer, that contract can completely eliminate the at-will rule. If there is a commitment such as you will work for 2 years and will not be fired unless your performance drops, this can be binding. Fourth, union contracts. If you are a member of a union, your employment contract may protect you with a clause saying you cannot be fired without valid cause. And finally, some states offer additional protections. States like California, New York, and Illinois provide additional protections for employees beyond federal law in certain situations. The rules can vary depending on the state you live in, so understand this. At will does not mean anything goes. It means they do not need to provide a reason to fire you, but they cannot use an illegal reason. The difference is subtle, but that difference changes everything. Let's go back to David's story. He did not know his rights. He signed the package, he handed over his card, and left the workplace. But he later learned, 2 weeks before he was fired, he had reported a security issue at his workplace to management, and management had not liked that complaint. Was this a coincidence? Maybe, but maybe not. And this is where many people make a critical mistake. They quickly sign the package, in shock. In that moment, they have neither the energy nor the time to research their rights. But some packages, once signed, waive your right to file a lawsuit, meaning after you sign, they take away your right to say this was discrimination or this was retaliation. This is not an internet myth. This is a real trap. On the internet, you often read, an employer is always required to give you a written warning. Absolutely false information. That might apply in Germany, but this is America. No such requirement exists here. Or, if they give you less than 2 weeks notice, you get severance. Not always true. It varies depending on your state and your contract. So what should you do? If you have been fired and you believe it stemmed from discrimination or retaliation, first know this. Do not sign that package. Get advice from a lawyer. And know this, knowing your rights does not force you to file a lawsuit, but not knowing ties your hands after the door has already closed. But do not forget, whether you are going to a lawyer or you want to avoid signing that package, you need to have a reason such as discrimination or retaliation. Let's go back to David. David eventually goes to a law firm to discuss the matter with a lawyer. Even though the time between his complaint and his termination was very short, maybe there was something there, maybe there wasn't, but at least he now had an option. To have an option, you first need to know what questions to ask. Losing a job is not just a loss of income, it causes a loss of identity and a loss of reputation. And that loss of reputation walks alongside you even when you are alone. That is why knowing the law prevents unjust losses of reputation, and no one can unjustly take your joy of life from you. Rights only protect you when you know they exist. If you subscribe to my channel and support me, I would be very happy. See you in the next video.